negotiated a resolution that's for some reason more favorable than going to trial based on all the evidence, based on what your lawyer's advice is, based on what you feel is appropriate as well, and based on what the prosecutor is willing to do for you. So without a trial is dismissal or change of plea. Dismissal in DUI case is very, very rare. So it is the rare exception. It is not the rule, and there's a reason for that. Why is that? Because the legislature has completely intervened in the prosecutor's decision-making process. They passed a statute, subsection I, to 281387, and it flat out says, the state, meaning the prosecution, shall not dismiss a DUI charge unless there is an insufficient legal or factual basis to prosecute. So what that means primarily is they shall not dismiss a DUI charge just because the defendant deserves it, just because it's a first offense. There is no free pass in DUI now. It can't be because maybe the defendant is a public servant, somebody who's done such good things for the community. If it's a solid case, if there's not a legal or factual basis, the legislature just says that's it. No more dismissing DUI cases. So our emphasis, if we're looking for dismissal, if we really aren't seeing any other options to resolve a case, or we really, really need to not have a DUI, then as lawyers we're looking real hard and we're relying really hard on this language, trying to convince a prosecutor you have an insufficient legal reason or factual reason to proceed, and that's our job to really find those. In some cases it's a pretty solid investigation. There aren't any legal problems, there aren't any factual problems, and then you're negotiating what you can do, but dismissal is pretty much off the table. Quickly, a change of plea, on the other hand, means you've reached a plea agreement, you've negotiated a resolution, and you're going to set your hearing for what's called a change of plea. That's where the judge will either approve of the plea agreement or reject it if the judge feels that it's legally inappropriate. That's super rare that happens. Finally, you can go to trial. A bench trial is a trial to a judge, and the opposite of that is a jury trial. Every DUI, by statute, has the right to a jury trial. So every DUI case, you can have a jury decide if the evidence is sufficient to prove you guilty beyond a reasonable doubt and not rely just on the judge. However, if you and the prosecutor both agree to try the case strictly to the judge or to the bench, you can do that, but you'd have to waive the right to have a jury trial. So would the prosecutor. If you have a jury trial, for misdemeanor DUI, you get 6 jurors. 6 jurors, they must unanimously find you either guilty or not guilty. The evidence that's permitted is based on the Arizona rules of evidence, and the judge will decide on what's allowed and what's not allowed. 2 possible outcomes for trial is guilty or not guilty. So it's a black or white resolution situation. There's no, well, we feel bad for this person, so maybe we can find him partially guilty or find her guilty of some of them, but maybe lessen the punishment. That's what negotiations are for. That's what plea agreements are for. But trial, unfortunately, it's either guilty or not guilty. If it's not guilty, the charges for which you were acquitted will be dismissed, and if it's guilty, you proceed to a sentencing. A sentencing hearing will have major ramifications depending on if it's a misdemeanor or a felony and what mandatory minimums apply. So super extreme DUI versus a aggravated DUI versus an impaired to the slightest versus somebody who has a second offense within 7 years. Everybody's going to be facing different mandatory minimums. We're not going into all those details today, but there are several to be aware of. Jail has mandatory minimums ranging from just 1 day in jail all the way up to a minimum of 180 days, full 6 months. Or a felony DUI first offense, 4 months in state prison. So be aware there are mandatory minimums for jail. Maximums are based on whether it's a felony or a misdemeanor, but generally because they're so harsh to begin with, you can usually get the minimums unless you have prior convictions that might concern a judge. Monetary fines, there are mandatory minimum fines. DUIs are very, very expensive in terms of fines. The legislature did that on purpose to just make it, not only are you going to jail, but you're going to have to pay all this money. They're trying to convince people not to commit the crime. Whether that works or not, I'll leave for further debate one day. Maximum fines are also based on misdemeanors versus felonies. Rehabilitation, everyone with a DUI conviction will be required to do a substance abuse screening and counseling. If it's recommended by the counselor, usually something is recommended. A little hint on that, always go to an MBD certified agency. And the reason is, if you don't, the court might give you credit for it, but MVD is going to make you do the whole process again with one of their certified agencies. So they produce a list that your lawyer should be able to provide to you, and that list will tell you the list of certified agencies. The court will honor it, and MVD will honor it, so you do it one time and one time only. Community service is required for more serious DUIs. For a first offense basic .08 DUI, it's not going to be required. The judge can impose it, but typically will not. MVD, you may be getting suspended. If you get convicted of DUI, you also have to do ignition interlock. The new law is out that if it's just a DUI drug and there's no alcohol involved, so just marijuana, no alcohol involved, you can get around the ignition interlock requirement. It is possible. Generally speaking, every alcohol DUI, you're going to have to do ignition interlock for at least 6 months, best case scenario. Probation is discretionary by the judge. You might get probation, you might not. And my last thought for the day is, if you were to be convicted of a DUI, comply, get everything done, do your counseling, do the ignition interlock, make the court and judge happy, and when that's all said and done, definitely consider setting aside your conviction. If you did a great job with honoring the terms and conditions of your sentence, the judge will typically grant a set aside, and the set aside may help you in the future. So thank you for your time. Happy to answer questions if there are any. And again, my name is Ryan Stevens, and we're a criminal defense firm here in Flagstaff. So thank you very much.